Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is artificial intelligence putting data privacy at risk? A new wave of investigations in Europe. In January 2025, a Chinese artificial intelligence chatbot called DeepSeek emerged as a formidable rival to ChatGPT and its companion AI bots. Almost immediately, data privacy regulators in Europe launched investigations into whether DeepSeek violates EU data privacy laws, and at least one agency has blocked the app from Google and Apple stores entirely. U.S. enforcers are not far behind, but European regulators' concerns about AI and data privacy predate the arrival of DeepSeek on the scene. In today's episode, we'll hear from a data privacy law expert about the issues raised by AI chatbots in jurisdictions subject to the EU General Data Protection Regulation, GDPR, which governs how the personal data of individuals in the EU may be processed or transferred. We'll get caught up on the latest enforcement actions and understand where the concerns lie and the potential remedies for violations. But before we talk about that, I'd like to introduce my co-host, Derek Jackson. Hi, Derek.
Hi, Alicia. I'm really looking forward to our topic today.
Derek, would you like to introduce our guest and kick off the conversation?
Sure. Our guest today is Rory Macmillan. Rory is a founder and partner of Macmillan Keck, a law firm with offices in Switzerland and New York. His practice focuses on electronic communications law and regulation, data protection and privacy law, digital identification systems, and digital financial services regulation. Rory is also an accredited mediator of the UK's Centre for Effective Dispute Resolution, and he's a very active member of the ABA Antitrust Law section. Rory is currently serving as a vice chair of the Privacy and Information Security Committee. Welcome to our Curious Amalgam, Rory.
Thank you. Lovely to be here, Derek. Alicia, thanks for having me.
Great. So let's kick off our conversation. So for listeners who may not have been following these developments that Alicia just laid out for us closely, how long have European enforcers been investigating whether and to what degree chatbots and other AI technology threaten data privacy? And can you sort of give us a brief timeline of the enforcement in the area?
Sure. Well, authorities in Europe have been looking into AI for quite some time, but things have really heated up with the launch of ChatGPT coming in at the end of 2022. So by March 2023, Italy's data protection authority, that's the Gerente, suspended ChatGPT's AI chatbot service. So they ordered it to publish an information notice to describe its data processing. They said that ChatGPT had to clarify its legal basis for processing personal data for training purposes. You see, under the GDPR in Europe, you actually have to have a legal basis, a lawful basis for processing personal data in the first place. The Italians said it's not enough to say that this is being done to perform a contract. No, they would have to show that it was based on consent of users or quote unquote legitimate interest, which maybe we'll talk about more in a bit. They asked ChatGPT to use robust age verification methods. They said it to provide data subjects, meaning people whose data that was processing, a way to exercise their rights under GDPR, things like the ability to correct information about them where it's incorrect or verify what data it's processing about them, and to give them a way to exercise those rights. It also actually told ChatGPT to carry out a local awareness campaign. And then by the end of 2024, the Italian authority fined OpenAI 15 million euros. Now, that's the Italian sort of beginning of this, but things moved big time to Ireland. Now, this is partly because in the European GDPR system, you have national authorities and you have then a coordinating body at the European level. And the national authorities handle cross-border cases where the entity is established in those countries. So ChatGPT later in 2024 moved its jurisdiction to Ireland. So Ireland took over there. Ireland also has been quite active with other operators of chatbots. So they began proceedings against X, otherwise known or formerly known as Twitter, saying that X was using people's data without their consent to power its AI chatbox, which is called Grok. There was quite a bit of bluster back and forth between Elon Musk and the Irish authorities, but in the end, X promised to comply. So the Irish Data Protection Commission withdrew its proceedings. It was going to block X, but decided it could hold off. Around the same time, the Irish also started an inquiry into Google and whether Google should have carried out a data protection impact assessment, a DPIA, when it was developing its foundational AI model, which is called Palm 2. That was an update from an earlier model, before processing European citizens' personal data. So the Irish took on Google there. Then comes in, as Alicia said at the beginning, DeepSeek. And the authorities all accelerate and engage big time, right? So January this year, the French Commission Nationale Informatique et Liberté, that's otherwise called the CNIL, it announces that they're going to question DeepSeek about privacy and risks from its AI system. The Irish come back in and announce the same. Then February this year, so that's this month when we're recording, the Belgian, the Dutch data protection authorities make similar announcements. And the Italians, as Alicia mentioned, block DeepSeek's chatbox with immediate effect because it was not addressing privacy concerns, and DeepSeek has removed its app from the Italian App Store. So that's a snapshot. Things are really heating up over here in Europe.
So that's a nice overview. And can you, I guess, give us a little more detail? What are the concerns these various enforcers are picking up on? Are there sort of common themes across these different AI bots, or are there specific concerns with the different operators?
Yeah, there are very common themes, and actually those come out in a publication that the European Data Protection Board, the EDPB, put out in December. I mentioned the one-stop shop system in Europe where one authority takes the lead. Well, those authorities also have the ability under GDPR to ask this European regional body to give opinions. And the Irish turned to it and said, please, could you give an opinion, give us a view on some of the key concerns around privacy in connection with these AI bots. And so the EDPB has waded in and expressed a number of different concerns. Now, it has warned DeepSeek directly, actually, that it should anticipate further attention from enforcement authorities. But let me just outline some of the kind of issues that the EDPB, the board, has given its opinion on. So first is around anonymization and whether GDPR even applies or not to these AI models. See, AI models will use a ton of data to train their algorithms up, and they get those data from proprietary data sources, from web scraping, from third parties. And then the question came up, really, what would it take for that data to be anonymized so that it's not even really subject to the GDPR? The board said that really the personal data that's used in those models is ultimately still in the models, is still informing the results, and is actually, it can be extracted from the models. So you can ask for information about people in most of these models, and you will get information about people. So where it can be extracted, actually, they charmingly refer to it as regurgitated. Then you have trouble. It's not anonymized, and for it to be anonymized, the systems really need to make sure that the likelihood of it being extracted is made insignificant. Second area that they were really trying to figure out is when is a company actually legitimately using this data? What's the legal basis? I mentioned that under GDPR, you must have actually a lawful basis for processing data, personal data, where you don't have performance of a contract, which, as I mentioned earlier, the Italians had said you shouldn't really rely on that. Well, consent is one possibility, but they explored a lot the question of when is it a legitimate interest of the controller to be taking this data and using it to train up, to develop an AI model and to deploy the model. And they explored in some detail how to weigh up that legitimate interest. That relates to questions around the expectations of individuals and some of the risks to those individuals that need to be considered in the balancing exercise between the interest of the controller, which is trying to build a model free of bias, free of error, hallucinations, and yet the protection of individuals' privacy and risks to those individuals. The third area that has really come out in the European discussion has been around the deployment phase. You have a kind of rather simplistically, but a separation between development of the AI models and then their deployment. And if you have a model that has been developed with infringements of the privacy rules, meaning using personal data that they shouldn't have, using it in ways they shouldn't have, going beyond the purpose that they had for that data, that's trained up the algorithms. What happens then if someone else is taking that AI and is deploying it for particular purposes? And so you have now really a very active market in deploying models that have been developed, health sector, education sector, financial, all sorts of areas. What happens then if the model which has been built using that data which was in violation is now used? They said actually that it's not inherently a violation, it's not inherently unlawful, but those who are deploying AI models should carry out due diligence to check the sources that were used in the development of the model and also have contractual arrangements, representations, and indemnities and so on for compliance purposes. So there's quite a suite of themes that are coming together in the European discussion, in the technicalities there. The one other thing to be aware of, the European Data Protection Board is still looking at web scraping, and it plans to put out some guidelines on the limits of web scraping and some of the considerations that need to be taken into account when you're web scraping to take in data to train your algorithms.
Now, here in the U.S., so much of consumer protection law, and then certainly in the areas of tech, user protection law is focused on getting informed consent and, to a very large degree, obtaining consent in the form that regulators are happy with will generally, constitute, if not a complete defense, it's given quite a bit of weight. Is that the same under the EU's regime? Would that help the AI chatbot operators?
Yes, consent remains a cornerstone of the European data protection regime. However, two important things. The first is an awful lot of data you are going to want to get a hold of for your AI model is going to be hard to get consent for. It's coming from all sorts of places, and the more, the better. There's a direct kind of tension between the goal of minimizing the amount of data that is being collected and used in order to protect privacy, and on the other hand, the goal of having as much data as you can to best populate and inform your algorithms and to weed out the risks, to reduce the risks of bias and of error. So there is consent is vital, but it's going to be hard to get it because of the amount of data that firms are wanting really to capture. The second thing is that even if you have consent, it's not like some kind of blank check. You still have a whole suite of regulations to wade through in the GDPR that will apply even once you've got the data with consent. You have to only collect what you really need to collect for the purpose you're going to use it for, and you have to be specific about that purpose, and you can only keep it as long as you need it for that purpose. And there are limits on what you can do to process it further, and you must keep it, focus on protecting privacy and security and so on. So there's still plenty of regulation that applies even once you have consent.
And so in this framework, am I correct that where there's not consent, or perhaps even where there is consent and there's further processing that happens, the companies also have to claim a legitimate interest? And how does that come into play in the AI context?
Yeah, this is really important, Derek. This is in many cases where there is no consent and where you can't really rely on performance of a contract or the other lawful bases. Firms are needing to assert that they have a quote-unquote legitimate interest, which is a wonderfully open sort of basket of concepts. But it breaks down into three kind of core pieces. The first is that your broad purpose of processing here is lawful. So it's legitimate. It's what you're trying to do is is clearly articulated. It's lawful. Examples that the authorities have given are, for example, in this context, developing conversational agent to assist users, or building an AI system that will detect fraudulent content or fraudulent behavior, or detecting threats in an information system. So these are seen as legitimate activities broadly. This goes a long way, because if you're trying to build an AI system and you need as much data as you can to detect bias and remove or reduce hallucinations and errors, you do actually have a legitimate purpose in getting as much data as you can. So there's a kind of, again, the tensions built into this balancing test in how you constitute legitimate interest. The other key part of what you have to show in order to show that you have legitimate interest is that you've done a balancing exercise between the interests that you have as the business and the quote unquote interests and fundamental rights and freedoms of the individuals concerned, whose data you're processing. And that's a kind of a weighing up process. The kinds of things that the authorities want to see that firms have looked at would be the individual's interest in having control over how data about them are used, people's concern about a sense of surveillance, which can lead to self-censoring and a reduction of free speech. These are very big picture, broad concerns, but they also drill into the specific types of harms that individuals might suffer, things like harm to reputation, identity fraud. So just to give an example, my son looked me up on ChatGPT, found out that in addition to being a lawyer in this space, that I was doing other things that ChatGPT said I was up to, which actually turned out not to be accurate. So these are the sorts of interests that the authorities want to see that the operators of the AI systems have taken into account when weighing up the protection of individuals against, on the other side, their own businesses. So ultimately, a lot of this comes down to what is the reasonable expectation of individuals about what might happen to data about them. What's the context in which it's been collected? What's the relationship with the controller who's in charge of what's happening to that data? Was it scraped from a website? Was it already publicly available? Those sorts of things. But as you can tell, there's a lot of factors to be taken into account in there.
And here's another factor. What kind of factor does geopolitics play in all of this? It has not gone unnoticed that DeepSeek is based in China. To what extent are the regulators in Europe concerned about that?
Yeah, every second phone call I seem to have, or conference call, seems to have someone saying, putting the politics aside, ... And then these sorts of issues come up. Geopolitics is clearly in the background and quite often in the foreground here. So 3 things to mention, I think. The first is, you mentioned DeepSeek. So it's privacy policy. If you read it, and it's actually not that long, it's actually very readable, says in black and white that the personal data it collects is going to be transferred to China, processed on Chinese servers. So they're quite upfront about that. However, they don't really get into detail about what is the possibility that the Chinese authorities might get access to that data, which you've seen in the US has been a concern of the Biden administration when they put out an executive order last year on transferring personal data to adversarial countries. The European Union has similar underlying concerns. The transfer of personal data, including under AI systems, to other countries is only allowed if certain conditions are in place to protect the data, by and large. Either the jurisdiction has adequate protections, and China has not been deemed to have that adequacy, or there are contractual provisions or corporate rules amongst a group of companies or other protections in place. So this is one area where we might well see some enforcement to come. But two other sort of geopolitical context issues. One is, in contrast, if you look at transfer of personal data to the US, for instance, a lot of the chat bots here are run by US companies. That's a different scenario. Europe has agreed with the US under its data privacy framework, which replaced the Privacy Shield, the Safe Harbor, which Max Schrems brought down successfully through his cases. Europe has got this new deal now with the US, and under that framework, the US authorities, to get access to data about Europeans, have to jump through a number of hoops to prove the national security or criminal investigation purposes of getting access to that. Now, I'm not saying that for Europe's purposes, the US is viewed as an adversarial state, although Some are saying that in the current geopolitical context of Ukraine and so on. But nevertheless, there is at least an arrangement there for the US, for data to be able to go to the US. The third thing is the debate around digital trade now. Europe's been very aware that the big tech community has realigned itself somewhat, apparently, around the Trump administration, watching CEOs flying to Mar-a-Lago or standing behind President Trump at his inauguration. And there's some concern in Europe that the big tech companies might have diluted a little bit their lefter-leaning inclinations in exchange for support from the administration to hack away at the European regulatory regime. So the regulatory framework in Europe and some of the big enforcement actions against Google, Meta, and others have been criticized by a number of US commentators, even before and outside the Trump administration, but now particularly by the new administration, as being effectively non-tariff barriers to digital trade, ways of trying to cope with the fact that Europe has not succeeded in building its own great tech giants and is really dependent on the US ones. So there is a lot of geopolitical context to all that's going on, Alicia.
It sounds like a lot of drama to come, too.
So, Rory, turning to remedies, once a violation of this type has been identified, what kind of remedies do the enforcers have in their toolkit?
Well, we've kind of touched on some of them already. One is issuing a fine. And so we saw that from the Italian authorities with ChatGPT. Another is telling the firm to pause on the processing. And so we had that also with the Italians telling ChatGPT to stop, and the Irish starting their blocking proceedings against X in Ireland. Another is to order them to erase part of the data set that was collected or otherwise is processed unlawfully. Interesting, in the X case, the Irish authorities withdrew their order to stop processing, but they didn't tell X, you must go and delete the data that you have at the moment. They haven't stepped into that point. That may yet come. There may even be fines still to come. So the fact that they've allowed X to resume processing does not mean that X is off the hook entirely. In an extreme case, if they can't really remove the unlawfully processed data from the data set, then they could order the whole data set to be deleted, but that's kind of a nuclear option. Those are the enforcement authorities' kinds of remedies. We should remember also that data subjects, individuals whose data are being processed, also have rights to go to firms and say, you're processing my data, you should not be, and to object to that and to tell them to stop, either because it's directly unlawful or because in the balancing test I mentioned earlier around legitimate interest, that they are objecting to it and are going to push the company to justify the processing further.
And just as we have time for one more question, do you see on the horizon any effort to create any legislation that is specifically AI focused or chatbot, customized regulations for chatbots?
God help us. We have so much right now to struggle with. GDPR itself has so much to say, and untangling how it applies is complex enough. We have, of course, the European Union's AI Act, which started coming into force earlier this month already, not focused on privacy, although the harms of privacy damage that could be the result of operating AI systems could be something that those who are developing them and deploying them need to take into account. But at the moment, I think the focus of everybody really is on handling the existing regulatory regime and making sure we get coherent and manageable results.
Well, that may be a lot to ask for. Now, for anyone who wants more details and information about the topic of today's episode and other topics in data privacy law in the EU, I'm thrilled to tell you that our sister podcast, Trust and Trade, which is also produced by the American Bar Association Antitrust Law Section, is going to host a series of episodes with Rory and other guest speakers. So you can find Trust and Trade on all the major podcast platforms and under the Podcasts tab on the ABA Antitrust Law Section's YouTube channel. So now we're going to transition to the final segment of our program. Before we let you go, Rory, we need to ask you a question to get to know you a little bit better as a person. And that is, can you tell us something interesting or unusual about yourself that is completely outside of your professional life?
I'm a big lover of Argentinian tango, Alicia. I'm a regular dancer and I love it, but I dance in my socks. I take off my shoes because it gives me a better grounding on the floor. So I'm found kind of shuffling around the tango floor, trying to avoid the stilettos, which can jab into them, a bit like in those gangster movies where the guy takes the scissors and tries to jam it between the fingers of the guy who's sitting at the table.
Well, I'm sure they make dancing shoes for tango.
Oh, they do. They do, but I prefer just to be in my socks. I have a much better sense of being grounded right on the floor. My toes are spread out.
All right. Well, be careful on that dance floor. And finally, we're going to play a little game we call The Curious Hat.
And now it's time for The Curious Hat!
The rules of the game could not be more simple. Derek is going to select a random surprise question from our virtual hat. So take it away, Derek.
Right, Rory. So your Curious Hat question today is, do you like to cook? And if so, what is your specialty dish?
Oh, wow. That's a good one. I love to cook. And my son has also inherited my love of cooking. So he's 14 and he will cook you the very best risotto alla milanese, and I'll put that up as my favorite dish. He cooked it for breakfast the other day because he had leftover chicken from the night before and threw that in for a chicken risotto alla milanese.
Did you teach him how to make it?
Oh, yes.
Oh, all right.
But he's adapting it himself now. He's taking it further than my input.
Well, that's terrific. Thank you so much, Rory. And thank you, Derek, for a very interesting conversation.
Sounds like culinary school may be in his future.
Maybe. And for those of you who want more, again, check out Trust and Trade.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.